Commit to Wealth Nation, welcome to the Commit to Wealth podcast. I'm your host, Juan Vargas. Today on the show, we have Kim Lisa Taylor. As a securities attorney, Kim Lisa Taylor focuses on assisting small business owners and real estate investors with the structure of their investment opportunities involving capital raising. She is licensed as an attorney in California and Florida and has made securities law her primary focus since 2008. Kim is the founder of Syndication Attorneys PLLC, a corporate securities law firm that assists clients throughout the U.S. with their real estate securities offerings. Kim Lisa Taylor, welcome to the show.
Hey, thanks, Juan. Thanks for the invitation.
Thank you so much for being here on the show. And I know that this show is going to be action-packed and it's going to be, providing a lot of information, a lot of value to everyone involved and everyone listening. But I guess what we're going to do here is, I want to ask you what your background is, before you got into this. Tell us a little bit about your background, and then we'll kind of jump into, it's going to be more so a case study, right? So, let's go ahead and start with your background and tell us where you're calling us from today.
Actually, I'm calling today from Coeur d'Alene, Idaho. I have an office up here in the summer, and then the winters I have an office in St. Augustine, Florida. I'm, as you said, the founder of Syndication Attorneys PLLC. I started out to become an attorney. I was a professional geologist, and interestingly enough, during that time, I actually had a project that was inspecting HUD housing complexes around the country. So I had to put together a team of people and go do housing quality assessments. And then sometimes writing demo specs for projects that were just too far gone or doing enforcement actions against owners. So got my feet wet with multifamily, thought that was kind of cool, was really interested in doing that. After that, met and married my husband, and we started investing ourselves. So we actually got involved with some multifamily training, and then got a coach, and then went out and bought our own multifamily apartment complex with some friends. So we, in addition to a couple of vacation rentals, and then at one point, I actually managed a 264-unit apartment complex. So I invest just like my clients do, and I also, have some experience outside of that, but, a lot of it's related to multifamily. And then I've been doing this for the last 10 years, and a lot of my clients are doing multifamily, but they're also doing a lot of other things. We have clients that do mobile home parks, self-storage, retail shopping centers, office buildings, industrial parks, raw land, land development, you name it.
Got it. And it's nice to know that, if someone comes to you, then they're going to speak to someone that has experience in the actual doing, right? Not just drawing up the paperwork and representing them, but actually doing. And so that is always helpful. Let's kind of get into this. And the way we're going to do it today, I guess, is going to be through kind of like a case study. And so this is not going to be your typical, what is a security kind of thing. So we're hoping that, most of you, will know about this already by now. And if not, then you can go on our website and you can reach out to her and kind of get a little bit more information. When should someone reach out to you exactly? At what point in the process?
Well, so first of all, who should reach out to us? People should reach out to us if they're going to be using money from other people, whether those other people are going to be other private individuals. Okay, if you're using hard money lenders, you don't need us. If you're using just an institutional bank and your own money, you don't need us. But when you start bringing in other investors into your deal, that's when you need to be speaking to a corporate securities attorney to make sure you're structuring it correctly, make sure you're getting the best structure that's going to give you tax advantages, as well as make sure that you're compliant with securities laws if that's required. But we can also give you a lot of practical advice just on how to structure deals with investors in general. So that's who should hire us. And now, when should you hire us? We say that when you have a letter of intent, that's too soon, okay? Because real estate, as you know, Juan, is a numbers game. You're going to throw out a whole lot of LOIs, and only a few of them are going to stick, and some of them will get negotiated. Some of them will get to the purchase and sale agreement stage. So once you get to the purchase and sale agreement, that's when you should start thinking about your corporate securities attorney. You can always reach out to us in advance of that just to get a general knowledge of how to develop an investor database, and how to have investors ready and waiting that you can legally ask for money once you have a deal. And that's a good idea. But like you mentioned, there's a whole lot of information on our website about just, how to develop investor relationships and when you should start doing that, which is now when you don't have a deal, by the way. So anyway, 3 things we say. Hire us when you have a signed purchase and sale agreement, someone from your team has physically visited the site, and you reviewed the last 2 to 3 years of income and expense statements. Don't wait until you have completed all of your due diligence, or you're going to be cutting yourself short on the time you need to raise money while we prepare the documents.
Okay, so it's safe to say that it's not once you have an LOI accepted, you actually wanted to someone to reach out to you once they have a PSA signed and agreed upon, right?
That's right, because in my experience, just based on my own investing and that of my experience with my clients, is that once you have that signed purchase and sale agreement, you've physically visited the site and you've reviewed the financials and figured out all the things that the seller left out, whether intentionally or not. Now you know whether or not it's a deal. Okay, and you're 95% likely to close on that deal once you've done those 3 things. Anything else you might find during your due diligence process is going to be a deal negotiation point versus a deal killer.
Okay, got it. So once you have a PSA signed and agreed upon, then someone should reach out to you because, hey, LOIs are just that. LOIs. There's nothing set in stone. They're non-binding really. So okay, so we have a PSA agreed upon. Somebody reaches out to you. What happens next?
Well, so the next thing is you reach out to us and we start talking to you about what you need to do, and we'll help. We're going to ask you a series of questions. How much do you need to raise? Where do you think your investors are going to come from? What kind of financial qualifications do you think they have? Do you think they're all accredited? Do you think some of them might not be accredited? Do you need to advertise? And we're going to ask you all this series of questions to determine which securities exemption is going to be appropriate for your offering. And once we have that information, then we'll be able to give you a firm price on that. All of our rates are fixed fee. A lot of other attorneys probably work differently, but I would imagine that that's probably the point at which any securities attorney is going to be able to tell you what the anticipated fees are going to be. And then once you hire us, so you actually engage us, sign a fee agreement, and then at that point we'll schedule a deal structuring conference, and that takes about 2 hours where we'll get all the information that's needed from company names, how you're going to split money with investors, what kind of fees you're going to charge, and then draft the offering documents, form your companies. The thing you have to do during that process is prepare a property information package. So you're going to prepare the property information package that contains information about your projections for the property. What is your plan of operations for the property? Are you going to, is it a development project? Are you going to buy something and add some value to it? Is it a turnkey operation? How long are you going to keep it? And, what are you going to do to increase the value during that time? And how is that deal going to generate income for investors, and how long before they get their money back and start to see a return on investment? So you're going to talk about all those things in your property package. That's something that we would review and make sure that doesn't contain any language that is inappropriate or would be a red flag for securities agencies. And then we'll also make sure you have the right disclaimers and that you're accurately and truthfully describing your experience and how your companies are going to be structured.
Now, speaking of companies, do you also help with the setting up the LLC that's going to own the actual property? Is that something that you do, or something that you have to hire?
No, we do that. It's part of the offering package that we generally put together. So you're going to be working with your securities attorney to make sure that the offering package is complete and accurate and contains only relevant information to your deal. And then once all that is ready, you're going to have the final set of documents. You'll attach your property package to it. Then you're going to go out and start raising money from your investors. You will need a real estate attorney for a commercial property. Usually you're going to hire so we're corporate securities attorneys, and we do a lot of stuff relating to real estate securities. So people that are raising money from private investors for real estate transactions, but we're not real estate attorneys. So we're not going to handle your real estate transaction. We're not going to draft your PS, purchase and sale agreement. We're not going to help with your loan closing and all of that, or your escrow. That's what you're going to need a real estate attorney for, and they're the ones that are going to help you with those things.
Got it. Yeah, that was my next question. So I'm glad that you were able to clarify that. What is the actual, I don't know if you can share this information or not, but what is the range in the cost for setting up, all your drafting of paperwork and documents?
Yeah, we have, and I don't want this to sound like an infomercial for our firm, because I really want it to be educational, and, maybe, hopefully these are typical of what the experience you would have working with other attorneys, but, I don't know. I don't work with other attorneys.
Exactly,
but, yeah. We have products that range from $3,500 up to, $35,000. Most of your specified offerings are going to be, you should be budgeting around $15,000 for those. And realize this, you might have to pay those fees up front, but you're going to be able to be reimbursed from your investors for those fees once you close on the property. So you're going to budget that into your startup costs, and your all of your acquisition expenses would include those legal fees. So it'd be budgeting around $15,000. There's a range kind of up or down from that, depending on how much you're raising and how complicated the deal is going to get and how many entities you need. And some of that's going to be dictated by your lender, or the marketplace, or just what you're doing. But in addition to doing specified offerings, one of the things we do also are blind pool offerings. So pooled investment companies, where you're going to go out and buy multiple properties or multiple assets, or maybe invest in other people's deals and you don't know what those deals are yet. So something where the actual project you're raising money for hasn't been defined, but you have a business plan. We do set those up too, and those are the more expensive products, just because they're more complex, documents are more complex, more moving parts.
Yeah, and that's not nearly as common. I would say that that's more for those are the guys that have a ton of experience and have been doing this for a good while. Those are the guys that are doing more so the blind pools, right, so to speak.
Absolutely. So, yeah, you've got to have a track. There's two things you absolutely have to have a track record for. One of them is to be able to pool funds and raise money prior to having a property under contract. The other one is to be able to advertise for investors. So you're trying to get strangers who don't already know and like you to invest with you. Both of those things are going to require a significant track record. For people that are just starting out and you haven't syndicated properties before, then you're going to have to I always recommend, if you can, team with someone who does have experience, because that teaming with that person is going to give you leverage. You're going to be able to leverage off their experience, because your investors are going to ask you, well, why should I invest with you? What have you done before? And you're going to be able to say, well, we've put together this team of people who have significant experience doing multifamily or whatever type of investment you're doing, and have syndicated properties before. So you might have to do that for your first couple deals. Those people can usually help you sign on loans. The lender's going to look for that information also. They want to see somebody with some experience and some financial wherewithal. So that's the kind of stuff that both lenders and investors are looking for.
Got it. And what is the time frame? How long does this process usually take? Like up until this point where you've drafted the paperwork, from the time they engage you up until the point where everything's ready to go, what is the typical time frame, and how long it will take?
2 to 4 weeks is typical. Probably 3 to 4 weeks is more common. So that's why I'm saying don't wait until you've completed your due diligence, because if you've got a property under contract with a 90-day closing period or escrow period, you want to get raising money as early in that process as you can. So if you've got a 30-day due diligence period, you'd like to have your offering documents done about the same time as your due diligence, so you got the rest of the time to go out and raise the money while the bank is processing your loan. That's the best timing that works. The people that have trouble and the people that fail at raising the money and closing on the properties are people that wait too long in the process. They come to us and tell us, hey, we were closing in a month. We've already completed our due diligence. Now we've got to still start from scratch, and draft the documents. Unless they've already got their investors in place and ready to go, that becomes very difficult to raise the money in time. So they end up usually having to get an extension, or sometimes they end up losing the deal. So I always say, if you're going to syndicate a property and you're raising money from investors and you don't already have them lined up, then you need to have at least a 90-day closing period. And when you're drafting your purchase and sale agreement with your real estate attorney, get an automatic 30-day financing contingency extension, at least 1 and 2 if possible, where you can invoke that if the bank needs more time or if you need more time to raise the money. So if you can get that and negotiate it up front, it's going to cost you a lot less money to invoke that than it will if you try to negotiate that a week or 2 before closing, because then the seller knows they have you over a barrel and they'll request that you release a bunch of money to go hard, and now you're taking a bigger risk.
Yeah, I think a lot of the guys out there will tend to, I guess in their sense, they're trying to, take less risk by, waiting longer in the process once they already have the due diligence, complete, because they feel like, okay, this is a property that I'm for sure going to move forward with. But really, like Kim said, you have to start it as soon as possible. Once you have it pretty much, under contract, then contact her, and she'll be able to get that process started. That you can get it done within the specified time. If you have a 60-day closing or a 90-day closing, nowadays a lot of the properties are closer to the 60 days, and because of how heated it is, so that's even more more reason to contact her as soon as you can, as possible, to get it done. So you have drafted the documents. The investor has prepared the package, the offering package to their investors. What happens from there?
Well, let's talk for a minute about what the offering package includes.
Okay.
Because I think that's important for your audience to understand. So your property package for, say, a specified offering, you're buying an apartment complex, you're going to raise a couple $1 million. Just so you know, that is the median size of all of the Regulation D Rule 506 securities offerings that are filed with the SEC. They did some statistical research a few years ago and said, yep, the average amount that's being raised from private investors under this exemption is $2 million and has 14 investors. So I want you to remember that number 14, because you want to have at least 2 or 3 times that many people to approach when you have a deal in order to get it closed. So if you've got a 50-person database, you're probably going to be able to close a $1 million or $2 million deal. But if you only have 3 or 4 people, then it's going to be tough. So just going back to what the documents entail, if you're including any, well, first of all, we need to understand the definition of what's an accredited investor, what's a non-accredited investor. Mm-hmm. Accredited is anyone who has over $1 million net worth, excluding any equity in their primary residence, but you can include equity in rental properties or income properties, or someone who has $200,000 a year income if they're single, or $300,000 a year income if they're a married couple. So I can think of this as the 1, 2, 3 rule. Okay, either $1 million or the income requirements of $200,000 or $300,000. So anyone who's not accredited is somebody who doesn't have those financial qualifications. So most of the offerings that we end up writing are under federal law. We're typically drafting documents under Regulation D Rule 506 or Regulation D Rule 506B, okay, then or 506C. 506B allows you to bring in up to 35 non-accredited investors in your deal and an unlimited number of accredited investors. All of the investors have to be sophisticated. So you've got to understand their financial situation and what their investing goals are and things that they've invested in the past to be able to make that assessment. It's very subjective as to whether they're sophisticated enough to be in a Rule 506B offering. But generally that has to be somebody who has more than just a job with some savings or a self-directed IRA. That's one of the reasons that the self-directed IRA companies go out and do so much education, is to make those people sophisticated so that they can invest in deals like the ones that you have. But you can't do any form of advertising or general solicitation in a Reg D Rule 506B offering. That's 506B like boy. You can't advertise. So it has to be word of mouth with people that you already know or have pre-existing relationships, or that people in your company, other investors already know, and they're not advertising on your behalf. So that's the most common exemption that our clients start out with. If you're doing a 506B offering and it's going to include non-accredited investors, you're required to have a private placement memorandum. That's the disclosure document. The format, the content of it is prescribed by the SEC down to, they even tell you exactly what has to be on the front cover and the following pages. So that format is required. There's specific information that has to be in there, mostly related to the risks of the investment and all the different things that could go wrong and how people could lose their money, and all of the compensation that the management team is going to earn. Any possible way that they could earn money off this deal has to be disclosed to investors. So that's the private placement memorandum. The other part is we're going to set up your corporate structure. So we're going to work with you in that deal structuring conference to figure out what it is you're trying to do, help you determine the appropriate corporate structure for that. Usually for, say, buying a commercial property, you're going to have an LLC that's going to take title to the property and sell interest to investors. That's going to be manager managed. And then that manager of that investor level LLC is also going to be its own LLC. That LLC is going to have you and your management team in it. And that could be either managed by its members, or it could be managed or managed if there's just a couple of people who are going to be signing on loans. So you're always usually going to have at least two entities. Sometimes lenders will dictate even a third entity that's kind of separate and remote from the investors that will take title to the property. So, it can get pretty complex if you're going to be bringing in joint venture partners, then, or co-investors or anything like that, then, you may end up adding even a couple more LLCs to that mix. So that's, so we're going to draft the documents that are appropriate to that structure based on what it is you're going to be doing specifically for that deal. All right. The third thing that we draft is called a subscription agreement. And that's where the investor certifies and warrants to you that they do meet the qualifications for the investment, and that they are, understand that there's risks, and they've sought whatever legal, financial, or other advice they thought was appropriate before they made their investment decision. So that subscription agreement is kind of your protection. With those documents in place, with all of those documents in place, you've done a pretty good job of shifting the risk of loss from yourself to the investors. So they've assumed the risk by understanding, all the different things that could happen and still investing anyway. The fourth thing that we do is we will actually file notices with the SEC. There's something called a Form D that has to be filed with the SEC, and that has to be filed within 15 days of when you accept the investment from the first investor from any state. So that's the Form D filing. And then the states where your investors claim residency also require securities notice filings, and they all want fees associated with those filings. You have 15 days from when you accept investors from a new state to be able to do those filings. So that's kind of the whole, process of what the documents offering package is going to look like. It's going to be the PPM, the operating agreement for your investor LLC, any other LLCs in the mix, and your subscription agreement, and then the securities notice filings that are required to be able to claim this offering exemption. So that's the process for 506B. There is a 506C exemption also. That's the one that allows you to advertise, but then you're restricted to only accepting investors who are verified as accredited. So in the 506B, they could just fill out the subscription agreement and say, yeah, I meet these qualifications, I'm good. Okay, if they, in a 506C, they actually have to take a further step and show you that they are accredited. You have to have a reasonable assurance that they're accredited before you can accept their money. So then that would become part of your offering package, would be, something, maybe a letter that they could take to their CPA or their attorney or their registered investment advisor, or somebody with a license, or they could get that from another company, but they would provide that back to you, and you would keep that along with their subscription to show that you did indeed have a reasonable assurance that they were accredited before you accepted their funds. So that's kind of, the package is going to look very similar for 506C versus 506B. I did mention that if you only have accredited investors in your deal, that you don't have to have a PPM. It's not required. So you could just get away with the subscription agreement and the corporate structure, the corporate documents, the operating agreements. But that PPM is important to you. And the reason it is because if you start bringing people into your deal that you don't know very well, you're taking on a big risk. And with that PPM, you're giving yourself some added insurance that they're not going to be able to sue you if one of the things you described in the PPM goes wrong. Without that PPM, you keep that risk, and it's on you if one of those things go wrong, because they can always complain that, oh, gee, I wouldn't have invested if I'd known that, and that can just kind of open up a whole big can of worms.
Yeah. So that PPM is very important, whichever way you go, either it's a 506C, 506B, just do it anyway. Don't take a chance, and anyways, it's necessary for the 506B, like she said. Now you mentioned accredited investors for the 506C. You also mentioned that the actual income. So it was $300,000 for if you're married, right? So what if you're married and you both your income combined is at like a 275, and you don't meet that $300,000 mark? So what happens there?
Well, so then you would not be accredited, but you'd still be able to invest in a Regulation D Rule 506B offering that allowed non-accredited investors. You would just have to prove to that syndicator that you are sophisticated by, you've owned other businesses, you have finance or business or economics degrees or something that kind of gives you an advanced knowledge of the business and investing world. Or you've just, had a lot of investments in the past, you're a very savvy investor, something that would make you, or someone who's been through a whole bunch of real estate training courses, and so they understand how these syndications work because they've learned how to do it. They just don't want to do it themselves. But now they understand, and they can invest in someone else's deal.
Can they invest in a property by themselves? If they're legally married, but can they say, just put it on there that they're by themselves, and if they meet the single income minimum requirement?
Sure, someone could do that if they are married, and there's certain states that have that recognize common law marriage and community property. So you'd have to be aware of those things. So you're really trying to guard against the community property statutes. So if that were the case, and somebody who said, well, I make $200,000, but together my wife and I don't make $300,000, and they wanted to invest, then you could have them invest as their sole and separate property and certify that it's not community property, and then their spouse would have to get that notarized and agree to that.
Got it. Okay. Well, then let's kind of fast forward to where we were here just a couple of minutes ago. And so we have the capital raised, everything's, legit, everything's right. When do we open up the bank accounts and things like that? Or is that something that we have to do before we start raising the capital?
Usually you're going to do that as soon as once we've had that deal structuring conference and we go ahead and form the companies that you're going to use. Then you'll be able to go out and open up your bank accounts. A lot of times they're going to want to see those operating agreements, like Wells Fargo or Chase, or they'll want to see the operating agreements, so you might have to wait until those are done. Then you can take those in, they'll open the bank account, and you're going to open two bank accounts. So you're always going to open one for the investor funds, and then you might even open 3 bank accounts, because you might have a property management account that just your property manager has access to. You might have a bank account for the company that only you have access to, and that's where you're going to pool the funds from investors and make disbursements to investors. And then your manager LLC will also need its own bank account, because it's going to earn fees and maybe some other income from that investor level LLC. So you've got to have a place to put that. And if there's multiple members in your management team, then you would disperse any earnings to them from that manager LLC operating account.
Right.
Sometimes you'll even create a savings account for your investor level entity, because you may want to keep some money in reserves and keep it out of the general operating account, so that you can kind of keep track of that. And or sometimes your lender is going to require that you actually withhold reserves and keep a certain amount in readiness, and maybe even they're going to approve when that gets dispersed.
So now we have the bank accounts. We wire the money into these accounts. Okay, so now we're pretty much ready for closing at this point, right? We're we're getting ready for closing.
Yep.
Now what happens?
Well, so on closing, then you're going to get your HUD 1, your closing statement. So actually, prior to closing, you're not going to keep you're not going to let your investors send their money to the property escrow account. You'll never want to do that, because now if you do that, then you've given that seller control over their money. And if something goes wrong with the deal, they could hold it up forever and your investors wouldn't be able to get it back. So what you want to do is make sure that you keep that in your separate company operating account. Sometimes you might want to use a securities escrow account. So that might be an option for you as well. But you're going to keep that money in your separate operating account until the escrow agent tells you, okay, it's time for you to send the money. Usually that's going to be about 3 days before closing, and they're going to tell you exactly how much is needed to close, and that's all you're going to send. So you send exactly what's needed to close, and then you could have some excess money. In fact, you should have some excess money that you've raised to reimburse yourself for any out-of-pocket expenses that you paid getting this deal to the closing table, you or anybody on your management team, or however you got it. Also, any reserves that the lender is mandating or anything like that, and just excess cash, maybe for your acquisition fees or any other things that you've raised. So you're going to leave that excess cash in your company bank account, wire only what's needed for the closing, close on the property, and then you're going to do an accounting for your investors. So you're going to create your own accounting and saying, okay, here's what the HUD 1 statement that shows what was sent to the seller and dispersed through escrow, and then here's the rest of the money in the bank account, and here's how that some of that got spent. Then you're going to produce the receipts that show that I reimbursed myself for this, and this, and the members, the manager got made whole, and then we paid our acquisition fee, and here's how much is left. So you're going to want to do that within a couple months ideally within a few weeks of closing on the property, and just to show your investors, that the offering is safe and secure. You've got some excess cash in the bank. Sometimes you'll still be raising money even after closing. So when we write an offering, and this is very typical, you'll sometimes have a minimum dollar amount that you have to raise to be able to close on the property at all. But maybe that's not enough to pay your acquisition fee or reimburse yourself for expenses. So you can continue raising money up to a maximum dollar amount that's specified in the PPM. And maybe what you really need is somewhere in between that. So you can stop short if you need to, or you only want to raise what you need, because otherwise you owe a return perhaps on excess money. So you don't want to have too much in the bank unless it's required. So that's kind of how that's going to work.
Yeah, and then once you close on the property, then you have to make sure that you communicate properly with your investors, right? So what do you see is the biggest mistake that investors make? I know that you covered timing. They kind of reach out to you, once the process is already like halfway through. So besides that, what do you see is another big major mistake that they make and that they can avoid?
Well, there's 3 big mistakes I see a lot. especially with new syndicators and people who are new to raising money from investors. One, they want to find one investor that's going to take down the whole deal, and that's always a mistake. And the reason for that is because those investors are going to want some control over you and control over the deal, and they are going to start extracting terms from you that wouldn't be as favorable as if you had just gone out and raised money from individuals, $50,000 or $100,000 at a time. You would have much more control over your deal in that case than you would if you have a single investor coming in who wants to co-manage the deal with you and take a piece of what you would otherwise be earning for yourself. So just be aware of that. The other thing about them is that they often disappear right before closing. They string you along, and then all of a sudden they're not there anymore. And now you're stuck. You can't close the deal. And I've seen a lot of deals go away, and the problem is that if you get that far down the road with the deal, you've already spent a significant amount of money out of your pocket, maybe for your offering documents, your corporate structures, your due diligence, all that stuff. And if that investor is nowhere to be found 2 weeks before closing and you can't get other investors in place, then you're going to lose the deal. You're going to lose that money. And then the other thing that is, I call them whale investors. And I say, if you're in, thinking about finding whale investors, I want you to watch the movie about Moby Dick and remember the wake of destruction that was left in his path, because it's really, really unfortunate what can happen.
Right.
The other thing they'll do is they'll start renegotiating terms with you at the last minute, and you're stuck. So all of a sudden the deal isn't really that great for you. And then once they're in there, they don't really need you anymore. So if they want to get rid of you, they'll find a way. And they've got all the money. They got the ability to hire the attorneys. You got a piece of paper, but you're not going to fight them in a $200,000 lawsuit, so you lose. So be careful of whale investors.
I want to add something real quick to that.
Yeah.
And that is, you're missing, the biggest, a lot of guys want to raise capital, with from one or two guys, because it's so much easier for them, right? Because it's so much less paperwork and so much less, steps that they got to do. But then you also got to remember, and this is just a reminder that, if you are, using, really with any kind of loan, they're going to want this major investor, if he is actually putting in more than a certain percentage, usually it's like around 20%, they're going to want him to sign on the loan as a guarantor, as a general partner, whatever. So that's one thing to keep in mind as well, that you guys need to also know that while it can be easy to just raise capital from a couple guys, that's ideal, right? It sounds easy, but they're going to want to be them to be on the loan as well. So make sure that you are aware of that. Make sure that you account for that if that's the case.
Absolutely. That's really great advice. And yes, your lender is usually going to require people who have over a certain percentage of ownership in the company to be underwritten on a loan. And, you may need that, you may not need that, but, just be aware of that and make sure that your investors are aware of that, because some of them absolutely don't want to be underwritten. One way to keep people from having to be underwritten is to give them non-voting interests. When we draft an LLC, we're usually going to give the investors a certain amount of voting ability. It's limited, but the manager runs the day-to-day operations of the company and is able to sign on loans and get financing, all of those things. But certain major decisions are going to require some consent of the members, and if you want to amend the operating agreement, for instance, that's going to be something that requires unanimous consent, because you can't, they're not going to want to sign a deal that says that if you want to, you can change the terms and decide what you're going to pay them or change the splits or anything like that. They don't want you to be able to do that. And also they should have an ability to remove you if you're stealing money, you're not returning phone calls, you're not handling the property. And unfortunately that does happen. So a lot of investors just simply won't invest unless they see a manager removal provision. And we make it high. We say, hey, 75% of the investors, the investors holding 75% of the interests in the company are the ones that you have to have that level to say we want to remove somebody. And then it has to be for a good cause, and you have to have done some bad things before they can do that. But if any of those things occur, and sometimes it's not because of anything you did wrong, but what if something happened to you and all of a sudden you had a stroke, okay, and you no longer can do the job and you can't communicate? or unfortunately you pass away. Those investors have to be able to have a mechanism in place so that they can salvage their investment, even if something horrible happens to you. So just realize
Great
that.
points. Yeah.
Mhm.
Yeah, that's a great point.
There's one other thing, is that I think is a really critical mistake, and that is that you should be marketing for investors right now. Okay, so right now is when you're meeting them before you have deals, but you can't just meet somebody, grab a business card, and then start offering them investment opportunities. There's more to it than that. You actually have to develop a relationship. Think of it like dating. You're going to kind of court somebody and get to know them, understand what their goals are, make sure they're a good fit. And then you got to keep in touch, because you don't want to go meet somebody at an event and then call them 6 months later, hey, I got a deal. They're not going to remember who you are. So you have to have a way to get yourself in front of them and send them useful information that they actually review, or just develop a relationship face to face, in order to be able to continue to bring them into deals with you. If you take the time to set up an investor marketing program, then you will be far more successful with filling your deals when you have them.
Yeah, the chicken or the egg, which one comes first, the deal or the investors? Always build those relationships with your investors first, and it'll be so much easier for you to, once you do come across a deal, then there you go. You already have those build relationships, and it'll be easier for them to want to get in on the investment. So,
Absolutely.
yeah. Besides those 3 mistakes, is there anything else that we left out that you think that we need to cover?
Well, I think we kind of touched on it, but try to get somebody who has some experience in the kind of thing that you want to buy. Get somebody who's already got that experience and bring them in as a member of your management. It's going to really boost your credibility. You're going to be able to use their resume, put them into your property information package. So one of the things in your property information package you're going to have are the biographies of your team members. And you need to be able to instill enough confidence in your investors that they say, yeah, okay, these people look like they have a clue and are going to be able to do this successfully. So yes, I would invest. So that's kind of what you're trying to do. So make sure that you've got that. Timing is everything. All right. Waiting too long is the death knell for a deal. So don't wait too long to hire an attorney. Get the offering documents done early, but not too early. Okay. Make sure you got a solid deal. Don't start telling people about your deal until you have a signed purchase and sale agreement. Don't start pre-marketing it to investors or anything like that, because that LOI, like you said, it's non-binding. You can say it's binding, but it's not. It would require a lawsuit to enforce it, even if you said it was binding. So I wouldn't count on that. It's the signed purchase and sale agreement that truly is a binding contract. At that point, some other investor can't come in and offer $50,000 more and take your deal. And I have seen it happen over and over again. So beware of that.
Okay. Well, that is great and solid information. Thank you so much for sharing that. Thank you so much for everything, Kim. We really appreciate it. Where can my listeners go to contact you and find out more about you and your company, Syndication Attorneys?
Please go to our website at syndicationattorneys.com. Under the resources tab are a whole bunch of articles. We do free monthly teleseminars. We actually have one coming up tomorrow. So if you want to get involved in listening on these free monthly teleseminars, get on our newsletter mailing list, and we'd be happy to start sending you that information. But read some of those articles. They're all 1 or 2 pages long. The previous teleseminar recordings are on there. I encourage everybody on this call to listen to the one with Sam Freshman. That was a fantastic interview. And we all should know what Sam knows, because Sam's been raising money. He's raised over $1 billion from investors over 60 years. So I think he knows what he's talking about. And that really changed some of my thinking about raising money. I think it will help you as well. And then, look at some of the other resources on there. We've got some frequently asked questions and things like that.
$1 billion. That's it. Oh man, he's a rookie. He's a rookie. So, okay. Well then, that is it. And also Sam has a book, right? What's his book on Amazon?
Principles of Real Estate Syndication. You can get that on Amazon. I read that book early on when I was just starting out in my syndication law practice, and it was a fantastic book. And I've met Sam a few times over the years, and he's just a wealth of information. So let's we can all learn from our elders.
Yeah, that is right. You're 100% correct on that. So yeah, well, thank you so much, Kim. We really appreciate it. And we wish you continued success.
Okay, great. There's just one more thing I wanted to say is that we're able to help anyone, anywhere under federal law. I am licensed in California and Florida, but it's not just me in this firm. We have 6 people in our firm. We have paralegals, law clerk, other attorneys that work with us. So we're happy to do free 30-minute consultations. You can find out how to schedule one by going to our website and clicking the link there. But we're absolutely looking forward to talking to you as you build your syndication practice.
Sweet. Yeah. Okay. And that is syndicationattorneys.com, right? The website to reach out to you. Okay. Well, make sure you guys reach out to her if you guys need some assistance with setting up, your documents. So thank you so much, Kim, again. Well, I greatly appreciate it. And like I said, I wish you continued success, and we'll stay in touch.
All right. Thanks, Juan.
Thank you so much.